Dear students, subscribers, and the viewers, welcome to the IAS Mentor. This would be our lecture number 22 in the series Indian Polity. As it has been already stated, the larger objective of this particular series is to provide a broader idea on the topic Indian polity, and at the same time, we'll also cover some of the important books relevant for the UPSC examination, especially the books like LAXMIKANTH would be covered in depth as we'll complete this particular series. Of course, it will take some time before we will complete this particular series. It will take at least 3 months or 3.5 months from now to complete the entire series, so that we can make a thorough analysis of the book LAXMIKANTH and also the Indian Constitution, which can be really beneficial to the students. This series will not only be useful for the students preparing for UPSC examination, but it will also be extremely useful for the students preparing for various other competitive examination, including the state public service commissions. And in line with the larger objective of this particular channel, we'll not only do the Indian polity, but we'll also take up probably the other subjects. We might also do current affairs as we'll proceed, and to provide a lot of good content to the students. So that's the one of the important objective. So we'll move on to the next topic that we are already discussing. So we are discussing the fundamental rights. So we started from the very beginning and we have come to the fundamental rights. And in the fundamental rights, in the last class, we are looking into Article 12 of the Constitution. We are trying to understand as to what is the definition of state. So now we'll move forward. We'll try to understand Article 13 of the Constitution. Very, very important for you to have a good understanding of this particular area. But before I get into Article 13 of the Constitution, let me just give a brief idea as to what we have seen under Article 12 of the Constitution. So what is Article 12 of the Constitution? First thing that we have learned is Article 12 of the Constitution defines the term state. Now, what do you understand by the definition of the term state? And whatever is given in Article 12 is a definition for the state within Part 3 of the Constitution. So, I have made it very clear that it is not a general political definition for state, but it is to define as to what is state for the purpose of Part 3 of the Constitution. And what is Part 3 of the Constitution? The Part 3 of the Constitution is talking about the fundamental rights, which are basically available to the citizens or to the individuals, and against arbitrary action of the state. So that means if any arbitrary action is done by the state, then the affected individuals can approach the court. And when the affected individuals approach the court should be convinced that the action was done by the state. So thereby the fundamental rights got violated. So for which first we'll have to understand as to who are all the actors will fall within the definition of state, and if those actors do some action that would be violative of the rights of the people. And for which this purpose Article 12 of the Constitution defines as to what is state. And what you have understood as to what falls within the definition of state: the government of India, the government of the states, the Parliament of India, the state legislature of the states, state legislature in the states, and then we have seen the local authorities like the Panchayat and the municipalities. Now, apart from all those things, any other territory within, or sorry, any other authority within the territory of India may also fall within the definition of state. So this is exactly where there was problem as to who are these any other authorities, for which the Supreme Court of India has clearly said that if at all any of the other authorities which is not explicitly mentioned in the Constitution, that is in Article 12, then in that particular case certain parameters, certain criteria will be applied on a case to case basis to see whether those actions of those authorities will fall within the definition of state or not. For which they might see as to what is the share capital of the government, or what is the governmental control over those organizations or the authorities, what is their nature of duties. So some of these factors will be taken into consideration, based on which the court may decide whether that authority will fall within the definition of state or not. And apart from that, the Supreme Court has also made it very clear, even a private authority may fall within the definition of state when they are acting as an instrument or an agency of the state. That means when they are delivering certain services which the states are supposed to deliver, and thereby they are engaging or they are acting as an instrument or an agency of a state. Under such a circumstances, they may also fall within the definition of state. And then apart from that, the last question that we understood in the previous lecture is whether the judiciary will they fall within the definition of state. The judiciary will also fall within the definition of state if they are performing what is called as an administrative function and not when they are performing what is called as a judicial function. Now, this is exactly what you have understood in the last class. So, it should be very clear to you that the definition of state is only for the purpose of part 3, and most importantly, the definition of state is relevant only if the fundamental rights are enforceable only against a state. If the fundamental rights are open not only against a state but also against the private authorities, also against the private individuals, then there is no need to see that who has done that particular action, because then the right is enforceable against both the state as well as the private individuals or the private entities. So, there is no problem. But whenever a right is available only against, or it can be enforced only in case the action is done by the state and thereby the violation requires a remedy in the form of going to the courts, then it has to be seen as to who has done that particular action. So, in the last class itself, I have given an example. Say for example, if a public employment, when there is a discrimination, then it has to be seen whether it is done by the state or not. It has to be seen whether it is a public employment or not, because Article 16 says that there shall be no discrimination in public employment by the state. So, the state shall not do any discrimination when it comes to public employment. So, the action should be done only by the state, and then only if there is a violation we will have a remedy. But there are certain fundamental rights which is available both against the state as well as the private individual. Say for example, in the last class I have taken the example of untouchability. So, similarly, let me take the example of what is called as trafficking. Article 23 of the Constitution provides protection against human trafficking, forced labor, bonded labor and all those things. Now, this shall not be done either by the state or by the private authorities or by any private individual also. And hence, if somebody is engaging in trafficking, then there is no question of who is doing that, whether it is done by a state or whether it is done by a private individual, because in this case the right is enforceable both against the state as well as the private individuals. But whereas on the contrary, if some of the rights are available only against the state, then it is very important for us to see as to who has done that particular action. Is it state or a private entity? So, if it is only against the state, then if the state does it, then there is a remedy for the individual. Otherwise, there is no remedy in the form of a fundamental right. So, that is basically what you will have to understand. Now, with that understanding, we will move into the next important article in the Constitution, that is Article 13 of the Constitution. Article 13 of the Constitution is very, very important because Article 13 of the Constitution gives primacy to the fundamental rights. When I say primacy to the fundamental rights, Article 13 of the Constitution gives a highest priority to the fundamental rights guaranteed in the Part 3 of the Constitution. How Article 13 is giving this primacy to the fundamental rights given in Part 3 of the Constitution? Article 13 is giving the power of judicial review to the courts. And to what extent this power of judicial review is given to the courts, we will try to understand. But before that, what do you understand by judicial review? Now, judicial review is a power which is given to the courts to review the actions of the other two organs of the state. What are the other two organs of the state? The legislature and the executive. Judicial review is a power which is given to the courts to review the actions of the legislature, that is laws made by the legislature, and the executive, the laws implemented by the executive. In both the cases, if they are in violation of the Constitution, then such an action can be declared to be invalid. Such an action can be declared to be unconstitutional. Such an action can be declared to be what is called as null and void. That is, legally it will not have any effect. So, this is basically the power of judicial review. So, what is judicial review? Judicial review is a power of the judiciary to review the actions of the legislature as well as the executive and declare them to be invalid if they are in violation of the Constitution. Now, this is a general definition of what is judicial review. But however, Article 13 is giving the power of judicial review to the courts with regard to protecting the fundamental rights. So that is what you'll have to understand. So what is Article 13 in crux? Article 13 is saying that if any law, if it is in violation of the fundamental rights, then to that extent that law can be declared to be invalid. That means if at all there is any conflict between a fundamental right and any of the other laws which is made by either the parliament or by the state legislature. When I say other laws, say let us assume the ordinary laws. And if any law is made by the parliament or if any law is made by a state legislature, and if that law is inconsistent with the rights that is given in part 3 of the constitution, that is the fundamental rights, and those laws to the extent of their inconsistency can be declared to be invalid by the courts, and to that extent that power is given to the courts under Article 13 of the constitution. This is a very crux of Article 13 of the constitution. So that is exactly what we are going to see. But whatever I have discussed is only the overall crux, but we'll have to understand the minute nuances under Article 13 of the constitution, which we'll subsequently understand as we'll proceed. So what did we understand under Article 13 of the constitution? Article 13 is giving the primacy to the fundamental rights. And how is that giving the primacy to the fundamental rights? By giving the power to the courts to declare any law to be invalid if that particular law is in violation of the fundamental rights. And how do we know what is fundamental right? Whatever is given in part 3. So no law which is made by the parliament or by the state legislature shall be in violation of the fundamental right. In case of violation, which will prevail? The fundamental right will prevail. And to that extent, the primacy is given under the constitution. That is basically the crux of it. But however, if you enter further into Article 13 of the constitution, you will say that this law is not only restricted to what is called as a post-constitutional law, but this is also covering what is called as a pre-constitutional law. So that means under Article 13 of the constitution, neither a pre-constitutional law nor a post-constitutional law shall be in violation of the fundamental rights. So what do you understand by a pre-constitutional law and what do you understand by a post-constitutional laws? When I say pre-constitutional law, so these are all laws which has been in existence before the commencement of the constitution. Now we know that the Constitution of India commenced from 26th January 1950. So pre-constitutional law means before commencement of the constitution. So that's basically what is called as a pre-constitutional law. So can anyone give me the example of what is a pre-constitutional law? You might be knowing as to what is a pre-constitutional law. For example, when I talk of pre-constitutional law, you will have to understand the laws that is in existence before the commencement of the constitution. So for example, when India became independent and then after independence, the Constituent Assembly worked and they drafted the Constitution of India. And when they drafted the Constitution of India, you will also understand by then the Britishers already made a lot of laws for our country. So on 26th January 1950 when India became independent, it doesn't mean that the laws that were there in place before the commencement of the constitution, we are not using it. In fact, the criminal law that we have got today, the IPC or the Bharatiya Nyaya Sanhita, it's majorly what was brought in by the Britishers. Similarly, the procedural laws, the Criminal Procedure Code, the Indian Evidence Act. So these are all majorly the laws which was passed by the Britishers and it's still in force. So for example, the Official Secrets Act 1923 that came before the commencement of the constitution, which is still in force in our country. So these are all considered to be what is called as pre-constitutional laws. Now what do you understand by pre-constitutional laws? I am repeating it again. These are laws which were enacted before the commencement of the constitution, that is before 26th January 1950, but still used in our country, still practiced and put to effect in our country. And these are all called as pre-constitutional laws. And then there is something which is called as post-constitutional laws. These are all laws which is enacted either by the parliament or by the state legislature subsequent to the commencement of the constitution. Say for example, the Right to Information Act, RTI Act. So let us assume the RTI Act 2005. The RTI Act 2005 is an example of what is called as a post-constitutional law. Mahatma Gandhi National Rural Employment Guarantee Act 2005. So these are all basically what is called as post-constitutional laws. So that's basically what you'll have to understand. The number of post-constitutional laws, thousands of post-constitutional laws. Just for example, I've taken a couple of those things. So what is Article 13 is saying? Article 13 is saying be it a pre-constitutional law or a post-constitutional law. In either cases, they shall not be in violation of what is called as the fundamental rights. Whether the law is enacted before the commencement of the constitution, which is in force today, or the law is made by the parliament or the state legislature after the commencement of the constitution, which is in force today, none of these laws shall be in violation of what? Violation of the fundamental rights mentioned in part 3 of the constitution. And if they are in violation of the rights which is mentioned in the part 3 of the constitution, and to the extent of such inconsistency, they can be declared to be illegal, or they can be declared to be what is called as invalid by the courts. So that is basically the power that is given to the courts, or the power of judicial review that is given to the courts under Article 13 of the constitution. So this is basically the first thing that you'll have to understand. For example, let me take an example of both a pre-constitutional law as well as a post-constitutional law. So for example, many of you might have known about what is called as Section 377 of IPC. I'm quite sure you might have heard of this Section 377 of IPC. In fact, the Section 377 of IPC was criminalizing what is called as the sex against order of nature, or Section 377 of IPC was criminalizing what is called as lesbian, gay, bisexuals and transgender sex. Now, I'm not very much sure as to what is the provision right now, because Section 377 even today continues to exist, but the section might got changed after the Bharatiya Nyaya Sanhita Act. So, but I'm talking about the law before the BNS came in. So, as per the previous Indian Penal Code, there was a section which is called as Section 377 of IPC. And if you see the Section 377 of IPC, as I already said, it was criminalizing what is called as sex against the order of nature, or it is criminalizing what is called as LGBT sexual orientation. LGBT means lesbian, gay, bisexuals and transgender sexual orientation, or their sexual intercourse would be considered to be a punishable offense, because it was basically considered that such form of sexual orientation is against the order of nature. That's the idea. But however, the Section 377 of IPC was read down by the Supreme Court. The Supreme Court said that Section 377 of IPC, in the sense, to the extent that it is criminalizing the lesbian, gay, bisexuals and transgender sexual orientation, or criminalizing such sexual orientation, is in violation of the right to equality. It is in violation of other fundamental rights, especially the right to life and dignity. It is also a violation of what is called as a right to privacy, which is implied under Article 21 of the Constitution. And to that extent, this has been now read down by the Supreme Court. So this is basically what you'll have to understand. Now, why I have taken Section 377 of IPC is, Section 377 of IPC is a pre-constitutional law. It is not a post-constitutional law. This was brought in by the Britishers way back in the 19th century itself. And then even after India became independent, we continued with this particular law. Even after we had our own constitution, we continued with this particular law. So this is an example of what is called as a pre-constitutional law. So even a pre-constitutional law cannot be in violation of the fundamental rights. Now in this case, the primary question was that the heterosexual orientation is not considered to be a punishable offense. It is not considered to be a sex against the order of nature. A heterosexual orientation means sexual orientation between different genders. So that is not considered to be a punishable offense. But whereas sexual orientation among the same genders probably, or sexual orientation with the transgenders, these are all considered to be punishable offense as per Section 377 of IPC, which later was decriminalized by the Supreme Court. The Supreme Court said that you cannot criminalize all these things. That means you are violating the principle of equality, because every individual is entitled to have what is called as sexual orientation of their choice. And sexual orientation is something which is innate in an individual. So if they are doing it in private, and if the sexual orientation is on the basis of consensus, then the state has no business to punish all those things. And if the state is punishing for the sexual orientation, Even if it is a lesbian, gay, bisexuals and transgender form of sexual orientation, then it is basically intervening into the privacy of the individuals, because sexual orientation is part of right to privacy. And if you are punishing people on the basis of sexual orientation, then you are also violating the principle of equality. And therefore, the entire provision as it was designed is violative of the fundamental rights. And to that extent, these provisions has to be declared to be invalid. And to that extent, the provisions which was inconsistent with the fundamental rights has been declared to be what is called as invalid. So this is an example of how even a pre-constitutional law can be declared to be invalid. Now let us try to understand about a post-constitutional law. So post-constitutional law means what? Post-constitutional law means these are all laws which is made by the parliament or by the state legislature after the commencement of the constitution. Let me take the example of Information Technology Act 2000. Under the Information Technology Act 2000, there was one controversial section which is called as Section 66A, which has been struck down by the Supreme Court few years back. In the year 2015, it was struck down by the Supreme Court. Now, the Information Technology Act is a major law that we have today with regard to governing the communications through the information and communication technologies. So it governs all those things. And if you see, in the Information Technology Act, there was a section which is called as Section 66A. Section 66A criminalized or allowed the state to take action against anyone who is bringing any form of communication through the information and communication technologies which is menacing or disturbing in character. When I say menacing or disturbing in character, anyone who is putting any form of comments or probably initiating any form of communication using information communication technology which is considered to be a threat to the public order or menacing in character or threatening someone, then against all these forms of communication, action can be initiated. And there was also a provision for imprisonment under Section 66A of Information Technology Act. But the biggest problem with regard to the Section 66A of Information Technology Act is it does not define as to what type of information can be considered to be menacing in character, what type of information can be seen as threatening in character, what type of information can go against a public interest. And to that regard, it gives a lot of discretion in the law enforcement authority. And who is a law enforcement authority here? It is a police who is a law enforcing authority. So this Section 66A was challenged in the Supreme Court, that this Section 66A is giving arbitrary powers in the hands of the law enforcement authority, that is nothing but the state. And this arbitrary power also infringes upon the right to freedom of free speech or right to speech and expression, which is conferred as a fundamental right under Article 19 of the Constitution. And to that extent, this provision can be seen as violative of the fundamental rights, that is right to free speech and expression. This was the argument that was made in the court, and this argument was accepted by the Supreme Court, and to that extent, this Section 66A was struck down by the Supreme Court. So this is an example of what is called as a post-constitutional law. So try to have an understanding whether it is a pre-constitutional law or a post-constitutional law, that does not matter. As long as they are consistent with the fundamental rights, they can continue to exist. If they are inconsistent with the fundamental rights, then those laws can be challenged in front of the Supreme Court. And when they are challenged, the courts are going to see that whether they are in violation of the fundamental rights or not. And if they are found to be violative of the fundamental rights, and to that extent the law can be declared to be invalid by the courts. That is the power of the court under Article 13 of the Constitution. So first of all, we have understood that Article 13 is giving a position of primacy to the fundamental rights. How? It is giving the power of judicial review to the courts. And by using the power of judicial review, they will have the power to review both the pre-constitutional laws and the post-constitutional laws whenever they are challenged in front of them, to see if any of the provisions in these laws are violative of the fundamental rights. And if they are violative of the fundamental rights, and to that extent such a law can be declared to be invalid. So far it has to be very clear in your mind. Now the next important thing that you have to understand is, under Article 13, it also defines as to what is law. It may be a pre-constitutional law or it can be a post-constitutional law. It depends upon the timeline as to when the law was brought in. But what falls within the definition of law is further defined in Article 13 of the Constitution. That means anything that will fall within the definition of law under Article 13, be it a pre-constitutional law, be it a post-constitutional law, be it brought in before the commencement of the Constitution or after the commencement of the Constitution, and if they fall within the definition of law, then none of these things should be in violation of the fundamental rights. And if they are in violation of the fundamental rights, then they can be declared to be invalid by the courts. So that is basically what you'll have to understand. Now let us move forward and let us try to understand what are all the things that falls within the definition of law. So first it is saying laws enacted by the parliament and the state legislature. So whatever may be the law that is enacted by the parliament or by the state legislature, basically these are all nothing but the ordinary laws. Say for example, the Parliament has enacted Right to Information Act. The Parliament has enacted the Mahatma Gandhi National Rural Employment Guarantee Act. The Parliament has enacted the Consumer Protection Act. Today the Parliament has enacted what is called as the Bharatiya Nyaya Sanhita Act, or it has renamed the previous version of the Indian Penal Code. These are all laws enacted by the Parliament. And none of these laws can be in violation of the fundamental rights because they all fall within the definition of law. And hence they shall not be in violation of the fundamental right. In case if they are in violation of the fundamental rights, these laws can be challenged and they can be declared to be invalid by the courts by using their power under Article 13. Not only the laws made by the Parliament, but also the laws made by the state legislature. There are different states in our country. We have got 28 states in our country. So each and every state might have their own legislature. So when they make a law, they shall also not be in violation of the fundamental rights. So fundamental rights are given a very supreme position in the Constitution by virtue of Article 13. Apart from that, ordinances issued by the President and Governor shall also not be in violation of the fundamental rights. I am sure that the students who watched my previous lectures where I explained the key terms in the polity. So some of the key terms that I am going to repeatedly use it again and again. And for this particular reason, I have explained some of the key terms to make you understand as to what do they mean. So in the previous lectures, I also explained as to what is an ordinance. So you can go to those lectures and you can watch that particular lecture. But however, for the students who are directly watching this particular lecture, let me briefly explain you as to what is an ordinance. What is an ordinance? Ordinance is nothing but a temporary law that is made by the executives. So normally who is supposed to make the law in our country? As per our constitution, the law making authority is the legislature. So we have understood there is a concept of what is called as separation of powers. Separation of powers means there are basically three organs in the state: the legislature, the executive and the judiciary. The legislature is supposed to make the laws, the executive is supposed to implement the laws, and the judiciary is supposed to review the actions of the legislature and the executive. So this is basically the idea. So normally who is supposed to make the laws in our country? The legislature is supposed to make the law in our country. But the Constituent Assembly thought that there may be some unforeseen situation, or there may be some emergent situation, or there is some emergency like situation wherein the legislature may not be able to meet. Legislature means basically what? Parliament or the state legislature. But there may be some unforeseen situation where the members of the legislature may not be able to meet. And only when they meet, they can make a law. They can transact and they can discuss, they can transact and they can make a law. But there might be a situation where they are not able to meet in the first place. But at the same time, there might be need for an urgent law. There might be need to control certain things and to carry out certain business in our country which may require a law. So under such a situation, the country or the administration should not come to a standstill. So there should be an alternative way to make a law. And that alternative way to make a law is what is called as an ordinance. But unlike the law made by the legislature, that is the law made by the parliament or the law made by the state legislature, the ordinance is issued by whom? The ordinance is issued by the president or the governors. That means here who is making the law? Ordinance is also a law, but normally the law is to be supposed to be made by the legislative body. But an ordinance is a law, but it is made by an executive. And executive, who is that executive? The president at the union level and the governors at the state level. So both the president and the governors, they have the powers to issue what is called as ordinance. And if any of you who are watching this particular video, if you know as to under which article in the constitution the president has the power to issue the ordinance, and under which article in the constitution the governor has the power to issue the ordinance, you can put it in the comment box. So the president and the governors has the power to issue ordinance. So it's not an elaborate law making process. The president can just come and issue an ordinance. And similarly, the governor can issue an ordinance at the state level, while the president can do that at the union level, at the national level. So ordinance is also basically a law, but it is a law made by the executive, not by the legislature. Ordinance is a law made by the executive and it is temporary in character. That is what is very important. Unlike the law made by the legislature, which has a permanent character, the law or the ordinance issued by the executive is temporary in character. It has a very short validity in terms of how long you can implement that ordinance, unless and until the ordinance is placed in front of the legislative body or the legislature and the approval of the legislative body is got. That's an elaborate process as to how an ordinance has to be made. That we'll discuss it at a different lecture when we take up the parliament part. But right now try to understand what is covered within the definition of law in Article 13. It is not just the law made by the legislative bodies, but also ordinances, the temporary laws which are issued by the president and the governor. They shall also be falling within the definition of law, which means that the ordinance which is issued by the president and the governors, they shall also not be in violation of the fundamental rights. And if they are in violation of the fundamental rights, they can also be challenged in a court of law. So that's basically the understanding you should have. And then apart from that, what else is falling within the definition of law? Statutory instruments in the nature of what is called as delegated legislations. They also fall within the definition of what is called as law. What do you mean by statutory instruments in the nature of delegated legislation? So for which we'll have to understand as to what is called as subordinate legislation, delegated legislation. They all mean one and the same, or executive legislation. They all mean one and the same. I'm just repeating it again. Executive legislation, subordinate legislation, delegated legislation, they all mean one and the same. So what exactly is this subordinate legislation? Say for example, let us assume there is an act which is called as RBI Act. The RBI Act was passed and the RBI Act is empowering the Reserve Bank of India to make a number of rules to regulate the various other banks in our country. And when the RBI Act was made by the Parliament, let us assume, the RBI Act did not say as to what are all the rules that the RBI should make. Rather, it is only saying, okay, we are making an RBI Act, and by that we are making this RBI as a statutory body, and we are making RBI as a banker's bank. And this RBI Act will give the power to the Reserve Bank of India to make further rules. And through that rules, it can govern the other banks in our country. And that's basically is how the law is made. So this RBI Act is nothing but the RBI Act is a parent act or a parent law. And that RBI Act is giving powers to whom? RBI Act is giving powers to the Reserve Bank of India. And the Reserve Bank of India can make a number of rules. It can make rules with regard to issuing new license to the other banks. It can make rules with regard to the reserves that the banks have to maintain. It can make rules with regard to how the banks can lend money to its borrowers. It can make rules with regard to what shall be the interest rates that the banks have to maintain. It can make rules with regard to even managing the non-banking financial companies or the institutions in our country. Now, to that extent, the Reserve Bank of India Act itself is not saying all these provisions or all these rules. The Reserve Bank of India is only making the RBI to make all these things. So, the law that is made by the Parliament would be considered to be a parent law. But on the other hand, the parent law is also giving some element of power to the Reserve Bank of India to make the further rules. And probably the rules that would be made by the Reserve Bank of India would be considered to be what is called as delegated legislation. So while the Parliament has a power to make a law, they have made a law and further they have delegated some of the power upon the RBI to make further rules to manage the banking system in our country. And that's basically what is called as a delegated legislation. That means that the law making authority of the Parliament is further delegated down to what is called as the Reserve Bank of India in this particular case to make further rules and to govern the banks in our country. So while the Reserve Bank of India Act is a law or it is a legislation, but whatever rules that the RBI has made under the Reserve Bank of India Act would be considered to be what is called as a delegated legislation. To make it further, make you understand, let me take another example. Say for example, we have an act which is passed by the parliament which is called as a Motor Vehicle Act. And that Motor Vehicle Act is a law or a legislation which is passed by the parliament. Under the Motor Vehicle Act is empowering the traffic department or the executives in our country to make rules, to regulate and to ensure the safe practices when people move around in the public. Say for example, as per the rules, the implementing authority can make rules as to what would be the fine when they are not wearing the crash helmet, what would be the fine for not wearing the seat belt, what would be the fine for drinking and driving, what would be the fine for other inappropriate behaviors under the act. So these fines are made as rules by the implementing authority. So while the law made by the parliament is a legislation, while the law is empowering the implementing authority to make further rules, to implement the law further effectively, and the rules that is made by the implementing authority is what is called as a delegated legislation. But now coming to the question of Article 13, even the delegated legislation which is made by any of the authorities for which they derive the power from the parent law, so those delegated legislations or the rules made by the implementing authorities shall also not be in violation of the fundamental rights. That means neither the parent law or the delegated legislation or the rules made under the parent law, so both of them shall be in violation of what is called as the fundamental rights. And if they are in violation of the fundamental rights, they can be declared to be invalid. Okay. And then the last important thing is, so far what you have understood, we have understood that the laws made by the parliament or the state legislature, the ordinances issued by the president or the governor or the delegated legislations, they will all fall within the definition of law. But not only these things, even the non-legislative sources of law. Non-legislative sources of law means these are all laws not enacted by the parliament or the state legislature. They are all non-legislative in character, which means they are not enacted by a legislative body, but there are certain customs and practices and norms which is practiced by people over a period of time, which is also recognized as a law in our country. Say for example, there are a lot of customs which is still practiced in our country, which are all recognized as a law in our country, especially when it comes to the personal laws, especially when it comes to the practices like marriage and divorce in various religions. A lot of customs is recognized under the Hindu Marriage Act. A lot of customs is recognized under the Muslim personal laws as to what is called as their marriage, what is a practice to divorce. So these are all merely based on what is called as customs. A custom is something which is consistently practiced for a long period of time and which is very unambiguous in character and which is very crystal clear as to how they follow it. So even those customs and practices may also fall within the definition of law, and even they shall not be in violation of the fundamental rights. Say for example, there are a lot of customs under the Muslim personal laws. The customs include what or how their marriage is to be done, how the divorce is to be done. Say for example, talaq is a way by which the divorce can be done in the under the Muslim personal law. So these are all based on customs, but still is considered to be non-legislative sources of law in our country. So even these non-legislative sources of law shall also not be in violation of the fundamental rights. One example that I can give you is, for example, recently the Supreme Court has struck down what is called as instant triple talaq. Instant triple talaq was struck down on the grounds that they were violative of the fundamental rights. So even the customs which are all non-legislative sources of law, even if they are in violation of the fundamental rights, they can also be struck down by the courts because they also fall within the definition of law under Article 13 of the Constitution. So this is basically what you'll have to understand as to what is Article 13 of the Constitution. So very quickly, let me just recap whatever you have seen. So that doesn't mean our discussion is over. So what we have seen under Article 13, Article 13 is giving primacy to the fundamental rights. And to what extent it is giving primacy to the fundamental rights? It is giving primacy to the fundamental rights to the extent, you will have to understand this. It is giving primacy to the fundamental rights to the extent that if any law is in violation of the fundamental rights, they can be declared to be invalid. And thereby it is also giving the powers of judicial review to the courts. Now, what are the type of laws? It can be a pre-constitutional law, it can be a post-constitutional law, it does not matter. If they are in violation of the fundamental rights, they can be declared to be invalid. So, based on the timeline, it can be a pre-constitutional law or a post-constitutional law, but what are the things that falls within the definition of law? The laws made by the parliament and the state legislature, the ordinances issued by the president and the governor, and apart from that, the delegated legislations and even the non-legislative sources of laws in the form of customs. If any of these things is in violation of the fundamental rights, all these things can be declared to be invalid by the courts under Article 13 of the Constitution, if they are in violation of fundamental rights. Now, before I complete my discussion on Article 13, this is very, very important. And unless and until we touch upon this area, our understanding of Article 13 will not be complete. And what is the other point that you have to remember? Will a constitutional amendment considered to be law under Article 13? That means, in other words, if at all a constitutional amendment is done by a way of which if any fundamental right is taken away, can that constitutional amendment also declared to be invalid under Article 13? So far we have been understanding as to what is law. So to put it in a very simple way, is a constitutional amendment considered to be law under Article 13? And what will happen if a constitutional amendment is taking away any of the fundamental rights? Can that be declared to be invalid under Article 13? That's the question. So this question was answered by the judiciary in number of cases because it is not explicitly mentioned in the Constitution. It was answered in number of cases and the judiciary gave its own response. But to put an end to all these judicial interpretation, the Constitution was amended by the 24th Constitutional Amendment Act in 1971. And by this 24th Constitutional Amendment Act, they made a change to Article 13 of the Constitution. And it is explicitly put in the Constitution right now that a constitutional amendment is not a law under Article 13. So what do you understand by this amendment? When I say that a constitutional amendment is not a law under Article 13, if a constitution is amended by a way of a constitutional amendment, and through that constitutional amendment, if you are taking away any of the fundamental right, the constitutional amendment cannot be challenged on the ground that it is violative of the fundamental rights. But whereas if any of the ordinary law is made by the parliament or the state legislature, and if they are violative of the fundamental rights, they can be challenged and they can be struck down under Article 13. So what is law under Article 13 is only these four things. What is law under Article 13? Ordinary laws made by parliament and state legislature, ordinances issued by president and governor, delegated legislations made by the executives or any of the other delegated authorities, and customs, which is a non-legislative form of law. So if any of these things are violative of the fundamental rights, they can be declared to be invalid. But if a constitutional amendment is taking away any of the fundamental right, that amendment cannot be declared to be invalid on the ground that it is violative of the fundamental rights. So, or in other words, a constitutional amendment cannot be challenged merely on the ground that it is violative of what is called as the fundamental rights. And that has been made clear by the Supreme Court by inserting this 24th, by amending the Constitution and making it clear by the 24th Constitutional Amendment Act 1971 by making appropriate changes in Article 13 of the Constitution. So does it mean a constitutional amendment cannot be challenged at all? And if you know the answer, you can put it in the comment box. What is the only ground on which a constitutional amendment can be challenged in a court of law? So you can put it in the comment box if you know the answers. Otherwise, we will discuss it in the coming classes. So with that, I am ending my lecture. Very, very important lecture. And if you have any queries regarding this particular lecture, you can reach out to me. You can reach out to me either through my Instagram account or through my Telegram channel. And before we wind up the lecture, so I have also have a question for you. Just have a look into this particular question. Which of the following shall not be violative of the fundamental rights of the citizens? Which of the following shall not be violative of the fundamental rights made by the citizens? Laws made by the parliament. Which of the following shall not be violative of the fundamental rights rights to the citizens? So that means if any of these things are violative of the fundamental rights, they can be declared to be invalid by the courts under Article 13. Can the law made by the parliament violative of fundamental rights? That's the first thing. Can the ordinance issued by the president violative of fundamental rights? Where delegated legislations made by certain authorities, can they be violative of the fundamental rights? So choose the correct answers from the codes given below. So which of the following shall not be violative? Okay. So 1 and 2 only, 1 and 3 only, 2 and 3 only, all of the above. So you can put the answers also if you know it in the comment box. And if you have any doubts, any questions relating to this particular lecture or in general related to UPSC examination, you can reach out to me through my Instagram account or through my Telegram channel. And if you know any of your friends or family members, you can recommend them to watch these lectures, and it will be really beneficial to them in their preparation process. Thank you very much. Keep watching. All the best.